In today's economic crisis, you will find that the threat of litigation, supported by powerful evidence, or actual litigation, is the only real choice when it comes to getting a permanent result with the bank. Without evidence, you got nothing. A securitization audit is all the evidence you will need to prevail. Getting a legitimate outcome for homeowners has become a far-fetched, impossible reality in our current banking debacle. By now, you should be aware that loan modifications are no longer effective, nor do they offer any sort of permanent solution. And the only thing a loan modification has ever done for a homeowner is offer a temporary solution. Statistics say that 94% of modification requests are currently being denied. The calculations that loss mitigation uses are set to fail. If you are one of the lucky homeowners who is offered a modification, lenders usually only offer a trial plan that is good for about 3 months. However, only a small percentage of those whom received a trial modification will receive a permanent modification. Everything is hedged on the homeowner failing, either on receiving a trial payment, foreclosing, or the trustee sale of the property. The lenders have been winning regardless of what you attempt. Property Solutions Center has seen thousands of these modifications that the lenders offer, yet only to find there's only a payment savings of a few $100s, and even that is only for a short period of time. Unfortunately, the lenders are far from actually helping homeowners. Lenders have never had any financial incentive to help because they receive money on acceptable terms. The reality is that the banks have no financial incentives to modify mortgages, despite the fact that they have a fiduciary duty to the investors to modify the loan. Every decision that the lenders make is about how much money they profit. So their mentality is this: the more money that is made today by foreclosing on the homeowner is ideal for them, instead of working with the owner and giving them something viable. Let's say you owe $200,000 on a loan where the house is worth maybe $150,000 at today's market value. The lender is going to factor in the fact that they can foreclose on your home and sell it for maybe $140,000 at today's market value. Or maybe it's going to make more sense for them to modify your mortgage. What they're looking at is a forecast or a net present value analysis and what your property will be worth in a predetermined period of time from now. They're going to ask themselves, which is better? What makes more sense for us today to earn the maximum profit potential? Making $140,000 today or modifying a non-performing loan? What they do is a cost-benefit assessment, looking at the possibility that in a year the lender might only be able to sell your house for $120,000. Just so you know, market analysts continue to predict housing values will continue to decline in 2011 through 2012. So obviously, your lender will choose foreclosure and make more money right now because next year the house is going to be worth even less than what it's worth today. Why do you think banks are intentionally dragging their feet to respond to modification requests? It takes the average lender 6 to 9 months just to review a modification request to see if it should be passed along to a negotiator. Now, why do you think that is? They're slowing the process down in hopes that the homeowner will get frustrated, give up, and go away. The way the loss mitigation department would review a file during the initial stage was by automated computer software for the lender, and it was instantaneous, and it would indicate a decision for the investor to see if it was worth it to modify the loan or to just sell. Now the loan modification review is held up for months before it is even sent to the negotiator. We find it a bit ironic that the process length has tripled in time frame over the past couple years. What we have come to discover recently is that instead of putting the TARP bailout money towards making the loan modification process easier and quicker, The banks instead misappropriated the billions of dollars received from the FDIC. All they're doing now is playing a chess match with homeowners and going through the semantics of the modification process with little to no real intent of modifying these mortgages. Every lender continually asks for updated documents, bank statements, paycheck stubs, 4506Ts. Then you send them, then they lose them, and the cycle goes on and on. This is just another tactic that they use to forestall and discourage homeowners to make them give up and go away. If you stand up against that treatment, you have to know what are your options. Having a securitization audit performed and providing the necessary evidence to prove whether or not your lender has legitimate ownership rights is the first step. This is the most powerful leverage tool that you can use with your lender, and your requests will begin to be heard. With legitimate ammunition like a securitization audit against your lender, the objective path for your home is to reach a settlement with the lender at fair market value or better, and an interest rate at today's market rates. Next, if your settlement offer is not within reason, you still have options. A mortgage litigation will be justified because the securitization audit gives you all the evidence to prevail in a courtroom. The securitization audit will be sufficient evidence within the litigation. If you decide to get in front of a judge, you need to have the evidence that the alleged beneficiary trying to collect or foreclose on the loan actually has absolutely no right to do so. If you pursue litigation with the securitization audit findings, that will provide the maximum result now that a law firm will litigate in front of a courtroom judge amongst a jury of their peers. The audit in front of a judge will be the most powerful evidence you can ever offer. This takes the power away from the banks because it is ultimately not their decision any longer. In litigation or in a settlement, the guidelines are much different because you're not going to be trying to fit a homeowner in a small bucket where the guidelines are worse than trying to get a refinance. To qualify, the homeowner doesn't need a hardship. Financials aren't even considered. They just have to be one of the millions of homeowners victimized by securitizations fraud. Let's go through a quick synopsis of the legal process. During the evaluation phase, the client will electronically sign the agreement and will be consulted by an attorney or a certified securitization auditor from our firm. A securitization analysis chain of title will be performed to gather the evidence needed to prepare the case filing. Once the due diligence is completed, then a securitization audit will be performed and the settlement process will begin. During the pre-trial negotiation of the settlement, many different causes of action are alleged. Some of the claims used against the banks will be malfeasance, statutory violations, third-party beneficiary claims, phantom investors and beneficiaries, unfair business practices, MERS violations, fraudulent foreclosure practices, robo-signing. There are so many different causes of action against these lenders that they are immediately placed in the hot seat. Once a settlement is reached, the attorneys will carefully go over every detail with the client so they can fully understand and make a proper decision before a final settlement is agreed upon. We'll now review possible outcomes from a successful settlement via a direct pre-trial settlement with your lender or via mortgage litigation. Pre-trial settlement. Once the securitization audit has been performed, then the attorneys will try and settle the client's claim and make an offer in compromise. What the attorneys are seeking here is a sizable principal reduction and a rate reduction. The way the pre-trial is negotiated is that our attorneys are leveraging the settlement against pleading the case in court. The second option, the amnesty program. That's when our firm will also be working on widespread legislation to provide sweeping reform. If successful, our firm anticipates that our clients will have preferential settlement options and ultimately a full lien strip. Now, this might only result if the lawsuit goes to trial. Remember, banks are being villainized in today's society as they become the direct blame leading this economy into an absolute mess. To summarize this presentation in one sentence, having a securitization audit performed on your property will greatly improve your chances to keep your home, and best of all, it will be at a fair market price. Thank you very much for listening. This has been a presentation by Property Solutions Center.